Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. So, today we are going to discuss a High Court judgment. I think it is Punjab and High Court judgment. The issue is whether the magistrate can order the voice sample to be taken, voice sample of the accused to be taken on the petition of the concerned police officer. So basically there are 2 points important. Number 1, Article 20 of the Constitution of India, that is self-incrimination, number 1. Number 2, whether the voice sample can be taken, number 1. So without permission, self-incrimination without permission, it can be taken. Second point, whether the magistrate can issue order for taking the voice sample. Normally, very recently in the Parliament, our Government of India, Ministry of Law and Justice, they have actually circulated, they have put forth that so-called Criminal Law Amendment Bill, yes, 2022. So, which a lot of furor is there, lot of dim is there. Of course, the opposition parties, they do not agree. What does it say? So, previously, when a person is arrested, the police officers are authorized to take his fingerprints and footprints. So, under which section of law? So, under the Identification of Prisoners Act 1920. But gone are the days, 1920, now we are in 2022, 100 years have gone. So, now not only fingerprints, not only footprints, now we have to take a DNA sample, saliva, hair, and nails, so many things. In rape cases, we have to take, is it not? Then, to make it available, to make it feasible, the government brought this 2002 amendment. Of course, this is only, I am telling only brief facts of that amendment. Amendment is big amendment. But opposition parties, they don't agree. They say that it is against to the doctrine of self-incrimination. You may be knowing Article 20, Clause 3, right? So, we'll come to that later. Now, while disposing the case of Ravi Prakash Sharma versus State of Punjab, in CRR number 531 by 2022 on 30th March 2022, Justice Avanish Jhingan of Punjab and Haryana High Court made it clear that directions to take voice samples by the magistrate. Of course, unless judicial interpretation is there, he cannot do it, but it is not against to law. It does not infringe the rights of the people under Article 20, Clause 3 of the Constitution of India. So this is the case. Now we will go to the brief facts of the case, then you will be understanding the case in a better way. Please remember, this Sharma, what is this Sharma? His name is Ravi Prakash Sharma. An FIR in crime number 10 by 19 was registered against Dr. Laklair Singh and Sajan Kumar, right? Okay, and some others under the Prevention of Corruption Act. So you know the cases, the doctor and the other doctors, Ravi Prakash Sharma and others. What happened is actually when they were working in a district medical and health organization, normally whenever you start some industry, you start some hotel, you start some shops, definitely the permission from the medical officers is compulsory necessary. That it is not unhygienic, all these things, people will not get affected like that, they will give permission. So when some people wanted to get the permission by starting a hotel and shop, these people demanded money, and there were discussions or there were telephonic conversation, that is cell phone conversation between them, right? So from the manager and what are the owners of the hotels, they have discussed at length regarding the illegal gratification. Now this telephone confirmation of Dr. Rajiv Prakash Sharma was taken into possession by the police. So the copy was available. That means it was recorded on the cell phone. Now they wanted to take the voice samples of the doctor. Yes, definitely it has proved. Suppose it is the original one, nobody can object. But this has come to them from some unknown source. So therefore, they wanted to get it checked, classified. They wanted to send it to the expert. So for that, they need the voice sample of the doctor. So they filed a petition before the magistrate. Magistrate innocently, he said the doctor has to give his voice sample. He objected for the same, so the matter went to the High Court. So High Court, please remember, as per Article 20, Clause 3 of the Constitution of India, no person shall be compelled to be a witness against himself. This is the doctrine of self-incrimination, right? Please remember, this was held in the case of Ritesh Sinha versus State of UP 2019. Yes. Please remember, here even Supreme Court also held that privacy is a fundamental right. Right to privacy is definitely a fundamental right, and if the person does not agree to give the sample, you cannot do, the IO cannot do anything. But here they said that this voice is for comparison only, right? Okay, now the defense, that is the accused Dr. Ravi Prakash Sharma and others, they have put forth so many cases. That is Aadhaar judgment, right to privacy. That is a retired justice case, Puttaswamy. Yes, Puttaswamy, retired justice case, Puttaswamy. I have forgotten. Versus Union of India, 2017, Aadhaar case. Normalga, we can quote that case also. So please remember, a number of cases they have mentioned. Let us not bother about them. Now the important point is whether magistrate can authorize the voice sample or not. This is the main point. Certainly no, because there is no provision in the CRPC, or there is no order from the Supreme Court. Normally, as per Article 142, I believe, Article 142 of the Constitution of India says whatever order, whatever decision given by the Supreme Court is binding on all the legal courts. Such interpretation did not come. So far, the interpretation is this: a person should not be compelled to be a witness against himself. Then how can they give? So magistrate is not authorized to give orders like that. But at the same time, please remember, the authorizing of the magistrate cannot violate the fundamental right of the person under Article 20, Clause 3. So that means it's only an error. It's only a mistake. Now he has to go and give his voice sample. Of course, it is better for him. Suppose if he did not speak in that phone, definitely he will come out with flying colors. Otherwise, it may be a problem for him. We don't know whether he has spoken in the phone, whether it is voice or not. Anyway, after analysis only it will come out. Anyway, this is a classic case where Article 23, Clause 3, that is self-incrimination comes into part. At the same time, magistrate is not authorized because Supreme Court did not interpret it in a clear, cut way. Right? If you know this much, it is sufficient. Thank you very much.